I have ingested the additional evidence and conduct. I will now integrate it into the existing analysis without inflating conclusions, and I will explicitly separate what is admissible for the harassment charge from what functions as pattern intent rebuttal evidence. No credibility weighting is applied, only legal relevance and contradiction mapping. 8. Prior conduct and pattern evidence. How it legally functions. Evidence set A. Repeated protection orders filed by Frederickson Facts asserted. Frederickson previously filed H. Roe, then a PPO against Thayer, and another defendant. The PPO was appealed and reversed. Legal significance. Neutral. This establishes a documented history of litigation-driven interaction. Reversal means the PPO does not stand as a valid finding. The existence of repeated filings remains a historical fact. Relevance to BAPE 18-91111C. This evidence does not prove harassment by itself. It is admissible to rebut legitimate purpose. It supports an inference of fixation or repeated targeting if the court allows pattern evidence. Use category, open quote, contextual rebuttal evidence, not standalone proof, close quote. Timer 9, firearms livestream, threat context analysis. Describe conduct. Frederickson appears intoxicated, livestreams from his home, hears a noise, retrieves what appears to be a shotgun, puts it back, retrieves a pistol, displays it on camera, states words to the effect of, open quote, I have no problem emptying this into your groin, close quote. States, open quote, court order or no court order, close quote. Critical analytical points. A. Target ambiguity. No name spoken. However, court order language narrows possible targets. At that time, Thayer is the subject of the PPO. This is circumstantial targeting, not explicit. B. Legal relevance to current harassment charge. This cannot be used to prove the CCTV conduct directly, but it is relevant for state of mind, reasonableness of Thayer's fear, rebuttal of innocent intent, pattern of intimidation. Especially important, if Frederickson later claims his conduct was harmless, this video contradicts that narrative. #C risk escalation factor. Firearms intoxication livestream threats equals high-risk contextual evidence, not required for harassment, but amplifies distress, reasonableness. Use category, open quote, contextual intimidation evidence, likely admissible with limits, close quote. 10. Courthouse proximity and surveillance admission. New statements. Frederickson stated on livestream, he didn't have to be in court. It was Thayer's court date. He was seated 12 feet behind Steph in the courthouse. Why this matters. A undermines coincidence defense. He acknowledges awareness of whose court date it was, physical proximity to an associated party, Steph, no legitimate reason to attend court himself. This directly conflicts with chance encounter, unintentional proximity, purely administrative presence. B. Establishes pre-contact awareness. He knew Thayer was involved. Associated persons were present. This matters because harassment statutes do not require surprise. It strengthens continuity between courthouse presence, parking lot pursuit, subsequent following. Integrated contradiction map. Frederickson assertions versus evidence. Assertion, evidence, conflict. I was serving a TRO. No papers, unlawful methods, sprinting, U-turn pursuit, harmless conduct, chasing, police intervention, admission, coincidental presence, admitted awareness of court date. No targeting, history of filings, directed conduct, no intimidation, firearms livestream statements. 12. Effect on harassment elements, updated. Directed conduct, strengthened by history and admissions. Repeated continuing acts, strengthened by pattern context. Reasonable distress. Significantly strengthened, prior PPO, firearms threats, awareness of fixation. Legitimate purpose. Further eroded, PPO reversed, statements inconsistent with lawful conduct. Court order or no court order, remark. Important limiting note, critical. To remain legally sound, a court would likely admit firearms livestream with limiting instructions, admit prior PPO history only for intent, absence of mistake, context, not allow it as propensity, he's a bad person. This actually increases credibility of the case if used correctly. 14. Strategic inflection point. At this stage, the evidence cluster supports a coherent narrative of escalation, not an isolated incident. You now have enough material to draft a probable cause rebuttal, draft a motion opposing dismissal, prepare a cross-examination trap, especially on TRO service claim, or switch to legal mode for a clean, citation-controlled brief suitable for filing. Tell me which path you want next. Understood. This new fact materially tightens the evidentiary chain. I'll integrate it precisely and show why it matters, where it applies, and what it rebuts without overstating. And 15, civil lawsuit activity, new contextual anchor. Facts as you've stated them. Fredrickson has been attempting to file a civil lawsuit since August 6, 2025. This is months before the courthouse pursuit. He is now on his fourth order to cure deficiencies. Thayer is a named defendant, among many others. No assumptions made beyond that. Number 16, why this is significant legally and factually. A, establishes pre-existing adversarial fixation. This confirms that before the courthouse incident, the parking lot pursuit, the vehicle following, the police stop, Fredrickson already had active litigation intent against Thayer. This directly rebuts any claim that the courthouse interaction was spontaneous, Thayer was an incidental or accidental focus. Fredrickson's conduct lacked prior motive or context. This is temporal proof of targeting, not hindsight inference. B, direct contradiction to legitimate purpose, narratives Fredrickson has asserted or implied. He was serving a TRO. He was acting within a legal framework. His conduct related to court business. However, a civil lawsuit with repeated deficiencies is not service of process, does not authorize personal pursuit, does not justify contact outside proper channels. Being on a fourth order to cure deficiencies suggests procedural noncompliance, court-managed restraint, not permission. This reframes his behavior as extra-procedural, not lawful. C, explains why Thayer is singled out. Previously, the defense could argue, open quote, why would Fredrickson care about Thayer specifically? Close quote. Now the answer exists in the record. Thayer is a named defendant. Litigation predates the incident. PPO filings, live stream statements, and the chase now align with an ongoing adversarial campaign. This removes ambiguity around directionality. Number 17, impact on harassment elements updated again. 1, directed at a specific person. Substantially strengthened. Thayer is not just present, he is a named legal adversary. 2, repeated or continuing conduct. Strengthened across forums. Court filings, protection orders, live streams, physical pursuit. This shows continuity of conduct, even if forms differ. 3, reasonable emotional distress, elevated, being followed by someone who has tried repeatedly to sue you, has sought restraining orders against you, has made firearm-related threats online, is now physically chasing you. A reasonable person standard becomes easier to satisfy. 4, legitimate purpose. Further weakened. Litigation must proceed through counsel, service, and court process. Personal pursuit outside procedure contradicts legitimacy. 18, evidentiary role of the lawsuit, important limit. This lawsuit evidence would not be used to say, open quote, he's litigious, therefore guilty, close quote. Instead, it is used to show motive, context, absence of mistake. Why Thayer, specifically, courts routinely allow this under limited purpose analysis. 19, emerging pattern, now clear, when all evidence is layered chronologically. 1, civil lawsuit attempts, AUG 2025, ongoing. 2, TRO, PPO, later reversed. 3, firearms livestream threats, court order or no court order. 4, courthouse presence despite no personal hearing. 5, physical proximity admission. 6, parking lot pursuit. 7, vehicle chase. 8, police observation and stop. 9, admission. I knew I shouldn't have done it. This no longer reads as an isolated lapse. It reads as escalation across domains. 20, critical contradiction snapshot. Open quote, courts discourage self-help in litigation. Fredrickson's conduct repeatedly bypasses formal process and substitutes personal action.